Ladies and gentlemen, thank you for standing by and welcome to the BIA Knowledge Leadership Series webinar. During the presentation, all participants will be in a listen-only mode. If you would like to ask a question during the presentation, use your chat feature located in the lower left-hand corner of your screen. If you need to reach an operator, please press *0. As a reminder, this webinar is being recorded today, Thursday, September 17, 2015. I would now like to turn the webinar over to Robin Thompson. Please begin, ma'am.
Thank you, Franz. Hi, everyone. On behalf of the team at BIA, welcome to our September edition of the Knowledge Leadership Series webinar, where our special guest will give us an update on privacy and security. Just a couple of reminders. Again, please remember to submit your questions through the chat window. And second, as you exit the program, you'll be prompted to answer a very short survey. Our programs are planned directly from your feedback, such as the one today, and your input helps us to continue to improve our presentations. BIA does not currently offer CLE for its webinar programs, but all attendees will automatically get a certificate of attendance for self-reporting for credits of CLE, CPE, CRM, and the like. Now we're coming to the favorite part of today's program. With us today to kick off our 4th year of presenting monthly educational programs is Michael Geske. Michael has over 2 decades of experience in litigation and legal consulting. From 2007 to 2013, he was a shareholder, member of the board, and manager of Affiliate Legal Solutions, a legal process outsourcing firm. Prior to that, he was a 17-year member of Arnold & Porter, where he litigated cases and regulatory proceedings of national significance. He regularly teaches CLE and professional development classes and writes about developments in litigation, privilege, professional ethics, and government surveillance. There's more information about Mike here on this slide and his LinkedIn profile and website. Mike, we are so happy to have you with us today, kicking off our 4th year, and I turn the presentation over to you.
Hi, everyone. It's my pleasure to be here with BIA. They've been very good to me, and I'm happy to be a presenter for them today. Today we only have 2 topics, but they're very timely. It's about the benefits of self-reporting data breaches to the Department of Justice and the Federal Trade Commission and other relevant enforcement agencies. We'll get to what those are later. And a very related topic, which is how to operate securely, not relying just on firewalls and malware and virus protection services, but by managing the risk of data breaches. You'll see here in part 1 the benefits from self-reporting data breaches to the government before the government comes to you and asks to do an investigation. There was on May 20th this year 2 statements, one released by the FTC called If the FTC Comes to Call, and on the same day there were remarks by Assistant Attorney General Leslie Caldwell at the Georgetown Cybersecurity Law Institute. For those of you attending, if you get a copy of these slides, all of these, primary source documents from the government are all hyperlinked here. That's why they're in a different color and underlined. And when you get the slides, all you have to do is click on them, and you'll go right directly to the government document. You'll see that all of these are very easy to read. All right? If the FTC comes to call, it's 5 or 6 pages. It explains what a data breach investigation entails and what the FTC will look for. And Leslie Caldwell's speech, it's 5 or 6 pages. They all take 10 minutes to read, but they're very informative, and they give you some very important baselines for what to do to set up an information security plan and to set up a plan to respond to a data breach. Let's start with the first one. the FTC statement. An FTC data breach investigation asks a pretty simple question. And this is a paraphrase, but what this FTC statement does on May 20th is unpack this statement here in red that I paraphrased. And the data breach investigation by the FTC asks the following question. Despite leaving the data breaches or the data security problems aside, were the company's data security practices, including its response to the breach itself, on balance reasonable? So just because you've had a data breach doesn't mean you'll be in trouble with the FTC or that the FTC will do anything other than investigate the breach. It doesn't mean the FTC is going to start an administrative action just because you've had a data breach. Rather, the FTC will first ask this question: were your data security practices on balance reasonable? Right? The FTC, as many of you know, but some of you may not, always has the outlook of taking a consumer's perspective. Will there be some kind of harm to the American consumer from what has happened, from what we're investigating? All right? And so to the extent that the company responds to a data breach by self-reporting to the FTC and the Department of Justice and appropriate law enforcers at the Department of Justice and local aid, what the FTC statement says, that in our eyes, a company that has reported a breach to the appropriate law enforcers and cooperated with them has already taken an important step to reduce the harm from the breach to consumers. Right? And they end up by saying it's likely we view that company more favorably than a company that hasn't cooperated. Right? There's a couple of things to make clear here. The FTC is not offering anyone a safe harbor. Right? Rather, they're just saying, if you cooperate with the law enforcement agencies against the hackers, and you do so quickly by calling on the Department of Justice and the FTC so that they can use their powers of issuing warrants and otherwise using their investigatory powers, then you've gone a long way towards reducing the likelihood of harm to consumers, or to the extent there is harm to consumers, you've done what you can quickly to get the government involved to help mitigate that harm. And it's more likely, if you do that, that the FTC will conclude that you've acted reasonably aside from the data breach itself. Right? There are a couple things to give you some comfort here. FTC data breach and data security investigations are non-public, right? Unless the FTC takes some additional official action besides starting the investigation, then there won't be any publicity about the investigation. Right? That means generally it's in an investigated entity's interest to cooperate in the first instance. Right? In the FTC investigation, the FTC has broad powers to go out and get information about the security breach. Right? Usually what happens if the breached company does not come to the FTC first, the FTC will learn about it from press reports or may learn about it from consumer complaints. Right? The FTC can go out and request information or documents about the security breach from almost anyone, from consumers, from the vendors and banks of the breached entity, from other companies similarly situated in the industry or with respect to the same kind of sensitive information that may have been breached. And they can go to your employees and ask them for testimony or information. Right? So you should not be playing any games here. If you go to the FTC, you should not expect a safe harbor, and you should be forthright with them and provide them with the information that you have. All right? But for all of its protestations that the FTC is looking for cooperation on investigating hacks and data breach, you have to bear in mind that the FTC is still a prosecutorial entity. And there are two warnings embedded in this FTC statement, although they're never stated expressly. Right? And that is the following. If you don't give the FTC cooperation in the form of providing the information it needs, it can go get that information elsewhere, and including all these other places, and it will go get that information. So don't play any games with them. You're not giving them complete information, or not giving them information that might otherwise be revealed only by your employees. Right? And putting the FTC to the trouble of going to these other third parties and asking for information about the breach reduces the incentive of the FTC not to give trouble to the breached company that it's investigating. And you should remember that the FTC has these broad powers to go get information and documents to fact check what you tell them in any presentation by your employees or your lawyers about the breach. So when you're making those presentations, be sure that you put in appropriate caveats. If you know something's a fact, you can state that that's a fact. If you're not sure but you're still investigating, you should say that, because that will explain why the FTC may come up with other information, and you should supplement the record of your presentation as soon as you can when you realize it's not been complete or that something stated in it was incorrect. Right? Because the FTC will check it, and they have broad powers to do so. Here's what the FTC is going to, the questions the FTC will ask itself and of the documents and information provided to it from either the breached entity or all these other parties that it can ask for information from, what the FTC will ask to assess whether the company has acted reasonably after the breach, right? First of all, they're going to look to see if you have an information security plan. We'll see later in the second part that the FTC and the National Institute of Standards and Technology and the Department of Justice have several documents that are shockingly and surprisingly easy to read and easy to tailor to individual companies' needs about how to generate an information security plan, right? It would behoove you, if the FTC comes to call, to already know those documents and have something resembling an information security plan already instituted, right? It's going to look to see about the cost effectiveness of available defenses. And by that they mean the off-the-shelf products. Did you at least have virus and malware protection programs installed? Did you have a firewall? And what did your IT department come up with as available defenses for monitoring or otherwise tracking who was logged on to your information systems where breached data was stored? Did you even have an ability to track who was on those systems, what they were doing while they were on those systems? Did you have someone assigned to monitor that on a regular basis, on a rotating basis? Or was it just something that you checked after the breach happened? Right? And they will also look to see if you've done any audits and risk assessments of your information security plan. Right? An audit implies that you've tested it, right? Meaning you've either yourself tried to breach your own system or otherwise hired a company to try and breach it. And whether your risk assessments were reasonable, right? That means you have to actually sit down and think about it. You can't just use an off-the-shelf product if that won't be sufficient, right? Here's something that will be very important. They will check your privacy policies and the security promises that you've made to consumers or other users of your online systems, all right? We'll get at the very end to the new case of FTC versus Wyndham. But if your privacy policy that's stated on your website is not current and does not reflect what you currently actually do with respect to protecting the privacy and security of the information of consumers and the users of your information system, that will not go well with you. All right? That will be considered an unfair and deceptive trade practice to state one thing in your privacy policy but not comply with it. And the same thing for the security promises made in the user agreements that your users or customers agree to when they log on to your information systems. They will also look to the circumstances of the breach, and that means who, what, when, where, how. What happened? What protections were in place? What consumer harm is likely? Did you store Social Security numbers? Were those taken? Did you store those Social Security numbers longer than necessary for your business purposes? Did you use them within an hour of a transaction, but keep them for a year unnecessarily? And they will look to see how the breach company responded, as I said earlier. The Department of Justice takes a general view now, announced on the same day as the FTC statement, that hacked companies are also victims. So if you've been hacked and you've suffered a data breach, you're a victim, much like a consumer. However, you have some control, and that's what the DOJ will be looking for. How you operated with that control and whether or not it was reasonable. The joint announcement by the Assistant Attorney General Leslie Caldwell recounts many of the government takedowns and captures of hackers and data breachers over recent years, right? Those have been conducted in cooperation with the private companies that were hacked. And the speech recounts how those occurred. And there's a good set of examples why it behooves the company early on to get the Department of Justice involved. because the Department of Justice can then call on the FBI, the Department of Homeland Security, the Secret Service, Department of the Treasury, the State Department, and, if necessary, foreign law enforcers, if they can trace back where the hackers are, right? And in the Department of Justice Criminal Division, there is the Cybersecurity Unit. That's in the Cybercrime and Intellectual Property section. Self-reporters almost automatically gain the Cybersecurity Unit's expertise, forensic tools, and the legal authority to issue warrants, right? To the extent that unit has learned, and Caldwell recounts in her statements much of what they've learned, how to identify where and who the hackers might be. The forensic tools that are used to discover that information, you're instantly calling upon that, and therefore, thereby, reducing the likely harm not only to your customers and consumers, but also other consumers in general. Now, in part 2, we'll see that the government has set up some documents and standards for minimal amounts of cybersecurity risk management. In the past, we've all operated on the basis of firewalls and malware and virus protection services, right? But those aren't good enough anymore, as we've all learned recently. The National Association of Corporate Directors last year issued a cyber risk oversight handbook. And in it, they make clear that cybersecurity is a board level and a C-suite level issue, requiring the management, time, and attention of the board and the highest executives. Right? Why is that? Because one of the defining characteristics of the last 3 or 4 years of cyber attacks is that hackers have learned that they can penetrate virtually every company's perimeter defense system, such as firewalls, intrusion detection systems, right? And they will exploit every layer of security vulnerability until they achieve their goal. In other words, if a sophisticated attacker targets a company system, they will almost certainly find a way to get in and to get your data, right? That's why we can't just rely on firewalls anymore. We can't just rely on virus protection and malware protection anymore. Rather, what we have to do is manage the risk of cyber attack. Right? How do you manage the risk? That's what we're going to get into in the rest of this presentation. Right? All risks are not the same, and all data are not the crown jewels. Right? However, there are some crown jewels in every company. It may be that the company has to decide that certain information is just not going to be online. It will only be in hard copy, in a handful of files at the company. Everything does not always have to be online. However, depending on how a company makes its money, all risks are not the same. Right? For instance, a bank gets much of its value from its retail banking customers by letting those users and those customers freely access their information over their smartphones, through their banking ATMs. And often, those apps on the smartphone will connect over a public internet connection, for instance, at a restaurant. And those are notoriously insecure. So are the Wi-Fi connections at hotels. In fact, some hotels monitor those Wi-Fi connections to monitor and prevent prostitution. So instead of just relying on firewalls, the board has to discuss what cyber risk and to identify which risks to which data can be avoided, which risks can be accepted or mitigated, and which ones can be transferred through insurance, and then make a specific plan associated with each approach for each kind of data. One size will not fit every company. Rather, it depends on how that company makes its money and what its plans for the future are. Here's where you can find out how to make such a plan, right? First of all, the DOJ in April issued a best practices document for reporting cyber incidents. This document, which is hyperlinked here, will tell you how to set up a response plan to a hack and how best to involve law enforcement and what information to collect that will be of most use to the law enforcers that you speak with, right? That follows largely from the National Institute of Standards and Technology document, the Computer Incident Handling Guide, right? The third document here, the Framework for Improving Critical Infrastructure Cybersecurity. That sounds like a document for improving the cybersecurity of critical infrastructure like nuclear power plants, right? But it's designed as a guide to help small and medium-sized companies logically think through the issues of identifying which data are the crown jewels, which data are not the crown jewels but are very sensitive, but yet we still need to be a profitable business to have it online, at least for certain users, and so forth. And then how to go about deciding how to manage the risk. Should we entirely outsource the security and the availability online of that information? Or should we retain some of that risk inside by managing it ourselves on a proprietary IT system? I know these government documents sometimes. I don't know, here's another government document with a plan for how I can save myself. Let me tell you myself, these documents are all easy to read and are surprisingly broad enough to guide you through the thought process that is generalized and with a common language that you will be able to think through the issues of your own company's information, how important it is to the business, how sensitive it is to consumers, and then set about a process for having a written plan about managing the cybersecurity of that information. And one of the most important parts of such a plan has to be having a response plan, all right? What to do when a breach occurs, all right? Most importantly, it has to be actionable, all right? Which personnel, specifically Mike Geske, Joe Smith, Matthew Brown, all have to be available by cell phone 24/7, no matter what, in case there's a breach. What procedures will be followed when there is a breach? First of all, you will call the CEO. Then you will call the IT chief officer. And what equipment will be used? Will we, after there's a breach, do we have another operating system that we can move our systems to operate while we forensically preserve the hacked system? All right? The response plan can help you identify and protect your cyber assets, all right? And specifically note how to collect and preserve data about the hacking incident while continuing to operate while the response is in effect, all right? Here's one of the most important pieces of information. If there's nothing else you take away from this today, you should take away this and tell your IT chief this piece of information, all right? You should make a prior contact and start a relationship with your local FBI field office, which is, there's one in all of the federal districts, all right? And the local Department of Homeland Security and state law enforcement, all right? Why? Because the local FBI field office will start the process of notifying the Department of Justice. If you have to look up in the yellow pages where the FBI field office is and who the chief public affairs information officer is there, well, you've already lost 2 hours if you're anything like me. If you already have a relationship with that person and make them number 3 that you're going to call after the CEO and the IT chief when there's a hack, you'll be well ahead of the game, right? They also have periodic outreach programs whereby they tell local businesses what are the latest advancements in cybersecurity. What are the latest advancements in managing risk? There are a couple warnings about hacking back, which has been sometimes, for people who thought they were sophisticated enough, a way of getting back at the hackers, all right? The Department of Justice recommends that you do not hack back. First of all, it's generally unlawful under U.S. statutes. You also risk an escalating war with an unknown adversary, and so it's most likely unlikely to succeed, all right? Call in the DOJ and the FBI. Let them decide how to respond to the hack. Don't hack back yourself. Here is just an overview of what those documents earlier cited say, all right? The order of making decisions about cyber risk management, all right? First of all, you have to catalog what data, assets, and services merit the most protection, all right? And then decide who must have access to that information and under what conditions, all right? It may be that it has to stay in hard copy, all right? It may be that we can't make money unless our users have free access to all the information we have about them, all right? In which case, you're going to allow the users to make a lot more mistakes. Let me say, most breaches occur from either employees or customers, all right? Because you just can't train all your users on appropriate setting up strong passwords, appropriate use of public Wi-Fi, if ever, right? And then once you've ranked all your data and your assets, then you have to set appropriate protections and the limits for each rank, right? And then comes the most important part. You have to test your system, right? If you don't sit and think through these issues in this order, or some order akin to it, then you will not have been coming up with a reasonable plan, which is what the DOJ and the FTC are inquiring about when they investigate a breach, right? Were your preparations reasonable? If you thought through your data classes and who must have access to it, under what conditions, and then tried to set appropriate protections for each rank, then you've gone through at least a reasonable inquiry and taken a reasonable approach to your data security, right? And that will serve you well when it comes time to respond to a data breach. So, what if, like every other company I work with, my company is too busy and financially stretched to come up with an information security plan, and we don't have time to come up with a response plan. We'll deal with that when the breach happens, if it ever happens. Well, first of all, it's going to happen, all right? 2 days ago, I'm sorry, it was in a legal paper notifying the public generally that hackers now know that medium and small-sized businesses do not spend as much time, because they don't have the same amount of resources as large companies, on their data security. They are the new targets for getting data and by hacking them. All right? So your company can't be too busy and financially stretched to do nothing. There's something you can do, short of trying to come up with an entirely a comprehensive program for your entire company that you're going to implement next week. All right? Identify your next upcoming segregable project. All right? Go through this inquiry with the information about that next segregable project that's coming up, a new product launch, a new business planning review system, a new HR system, right? Rank the information and cyber risks related to that project, and then draft and apply an information security plan for that project and apply it going forward on the assumption that the most recent data is probably the most valuable and the one of most value to the hackers, right? Start there. You'll learn a lot by doing it once. Then you can work back. Then you can have an improved information security plan that you can apply to the second upcoming segregable project. You don't have to try and bite it off all at once, right? You should do it as soon as you can, and you should do it reasonably by going through the inquiry that the government has suggested you go through, right? But if your company is stretched and it's too busy making money, then identify the next upcoming segregable project and come up with an information security plan for it and apply it. What if I can't get management attention? They're all too busy. They won't buy into it. They won't spend the time necessary. You can give them these warnings. Regulated industries, heavily regulated industries, such as banks and Department of Defense vendors, all now require, Department of Defense and banks generally now require their vendors to have risk management information security plans, right? Information security plans that are broader than and more comprehensive and recognizing the reality of current state of the art, that firewalls and malware protection are not sufficient in and of themselves, right? More and more, including by the National Association of Corporate Directors, suggest that mergers and acquisitions due diligence include an audit of information security, right? You don't want to buy a company that doesn't even realize it's been hacked for the last 6 months and buy an information security data breach with all of its attendant consumer and regulatory fines, right? And then we have the new case from the Third Circuit just decided last month of FTC versus Wyndham. In that case, Wyndham Hotels, it turns out, had an absolutely horrendous, the court suggested, non-existent security plan. Its privacy policy was so out of date, it was not doing anything that it said it was doing fundamentally to protect the privacy of its consumer and user data. Right? Let me read some of the issues. They had outrageously easy to guess passwords. They had not implemented even a firewall or used other rudimentary data security tools. They allowed third parties to connect to their network without authentication. And they did not use strong encryption software. They had no firewall at their critical network points. And they did not use any encryption for certain customer files, and did not require all of their users to change their default or factory set password at all. And so what happened was, over the last, since 2005, the FTC has been filing administrative actions suggesting that unreasonable cybersecurity practices were unfair under Section 5 of the FTC Act, which prohibits unfair, deceptive acts or practices affecting commerce. Right? But they had settled all of those cases, usually without publicity. And so Wyndham decided to challenge the FTC's allegations in its administrative action by saying that the FTC had settled all these cases without findings of fact and without any admissions of fault. And therefore, there was no guidance about what kind of cybersecurity issues or practices were fair or unfair, deceptive or not deceptive. Right? The Third Circuit held that the FTC could regulate cybersecurity under Section 5 of the FTC Act by saying that unreasonable cybersecurity practices were unfair under the FTC Act. And it held that what the FTC Act requires with respect to cybersecurity under the unfairness standard is a cost-benefit analysis of the relevant factors, including the probability and expected size of reasonably unavoidable harm to consumers, given a certain level of cybersecurity and the cost to consumers that would arise from investment in stronger cybersecurity. All of those factors should, by now, be old friends to all of us, because it's what's in all these documents that I cited earlier, and it's much akin to what the FTC looks for when it does a data breach investigation. That's a Third Circuit decision. It may get to the Supreme Court. I'm not going to predict what will happen there. There are other cases working through the courts as well that may have other Court of Appeals decisions that might come to a different conclusion. But this case, given the egregiousness of Wyndham's practices, is pretty good for the FTC standard. Be sure that you've thought through your cyber risks reasonably. That is, that you've cataloged your cyber assets. You decided which ones need what kind of security. You've implemented that security, and you've tested it. And with that, I think we're ready to take any questions.
Mike, we've got some great questions for you. The first one, for companies with multiple locations, which local FBI field office, DHC, state law enforcement should be contacted? In other words, what should a company consider as its location for responding to a breach?
That is a good question. I would say if you have 3 locations, that if you only have one IT director and it's only at the home office or wherever that IT director is, I would say that's the place where you should contact the FBI field office and ask for advice from that FBI field office about if there's any local Homeland Security offices that should be contacted. And if you have mid-level IT management personnel at your other offices, I would have them make a contact with their local FBI field office, because it may be that, that you're on a yacht in the South Pacific, if you're the IT director, and you can't be reached, in which case your testable response plan will have who to call next. And that may be the IT director at a secondary office. That person should already have a relationship with the outreach officer at their local FBI office. Those people at the local FBI offices will know how to contact other FBI offices.
Very good. Here's another really good question. You mentioned board management of the breach risk by acquiring insurance. How difficult is that to obtain, and how pricey is it? How in-depth is the insurance evaluation of risks that you've outlined?
Going out with an insurance broker to find appropriate insurance for your cyber risk is one of the best ways of testing and perhaps also finding a route to implementing an information security plan. All right? The cost of cyber insurance is based on what industry you're in, what services you offer, what kind of data you hold. Do you hold credit card numbers and social security numbers? Do you hold middle initials? Do you hold home addresses? And what kind of privacy policies and procedures you have, and what your annual revenues are, and importantly, what kind of what's the upper limit on the damages or on the amounts that the insurance company will pay out. Cyber insurance premiums can range anywhere from just under $1,000 to over $100,000. Right? A typical company with revenues of about $100,000 a year, with a $1 billion limit on the payout, can expect to pay somewhere around $1,200 a year in premiums. Right? That's going to vary a lot depending on what kind of information you hold, how long you hold it, what your revenues are, how many customers you have, and what limits what limit you would like on the amount that the company will pay out. It can be $5 million, it can be $1 million. And cyber insurance companies will often require the insured company to adhere to minimal security procedures and practices. There's a case currently being litigated where the insurance company is saying that the insured did not practice the minimal information cybersecurity practices that were specified in the insurance policy, and therefore the insurance company doesn't have to pay out. The coverage will be for a lot of anything related to the cyber breach, all right? How much the forensic investigation costs, the cost to get customer replacement cards. It'll cover regulatory fines. It'll cover attorney fees and customer notification costs. However, you should discuss fully and be sure you come to a meeting of the minds about anything that's excluded under the insurance policy.
Okay. Got one last question, Mike, before we close out. Who should be involved with the response plan? Do you recommend a committee? And if so, who should be on that committee? As with legal event planning responses, glad you agree that C-level or higher sponsor is key, but who should lead that response team? Is it IT? Is it legal?
I would say it should be IT above legal. All right, your lawyers will have to be there, but the IT persons and the business persons primarily responsible for using and understanding the information that's been breached, all right, so that they can explain and can recommend how to keep operating while making shifting operations to a non-hacked system, and what has to be transferred, what can be transferred later, what has to be transferred immediately and securely. So it should be IT persons and the business people should be on that response plan for the sake of the company's continuing operation. For the sake of contacting law enforcement, it should be a lawyer and probably the IT people, first of all, because they will be able to respond probably off their head when you call the FBI or Department of Justice field office. They're going to say, okay, we need the following 3 pieces of information. Can you get it for us in the next 4 hours? Or do you know the following? The IT people will probably be able to answer that off the top of their head or be able to say, we'll get back to you in an hour. And the lawyers will be there to protect them, right? One of the things you should, the lawyers should be aware of when it comes time to test an information security plan and audit it is you should keep any work product about the gaps. Here's where we failed in our information security. Here's where our response plan broke down because Mike Geske wasn't on his cell phone when he said he would be. Those kinds of work product, to the extent that liability is discussed, should be kept separate from the facts about what was found in the audit.
Well, thank you very much. I want to remind everyone that next month on October 15th, our monthly webinar will feature our most requested program, our annual update of risk and responsibilities, the ethics of legal hold, and this is the one program that has been applied for for CLE with Texas and is honored in states who have reciprocity to Texas. We'd like to thank everyone who attended with us today for your valuable time. Thank you for helping us make a successful kickoff to our 4th year, and we'd especially like to thank Mike Geske for his valuable time in giving us a great update on privacy and security law.